Welcome, everyone. I'm so pleased that you're able to join us today. Before we get started, I'd like to run over some housekeeping matters. First of all, as the law school at the University of Utah, as the University of Utah S.J. Quinney College of Law, we want to acknowledge that this land on which the school is based is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples and their traditional homelands. Also, as this program continues, if for any reason any of you bounce off and have to sign in using a different ID, like if you signed in with your email, but then you have to sign back in with your phone number, please email me at lori.nelson@law.utah.edu and tell me both IDs sign in so I can make sure that you get credit for attending the webinar. You have to stay on for the entire hour pursuant to Utah Supreme Court CLE rules. We will have time throughout the program for questions. Please put those questions in the Q&A and not the chat. And then we will monitor those questions. You can also monitor those questions. And if there is anything that you like and you see in those questions, the questions that get liked will rise to the top. Now, I'd like to introduce our panel to you. We have Rand Bateman of Bateman IP and Brent Hawkins from Bennett Tueller. Randy Jeffs of Jeffs and Jeffs was going to join us today, but he woke up with laryngitis, so he won't be able to participate. I'd like to turn it over to Rand and Bennett to introduce themselves, talk a little bit about what they've seen, and then we'll open it up for questions.
Okay. So those of you who don't know me, I'm Rand Bateman. I'm an IP attorney. I do both prosecution of patents and trademarks as well as IP litigation. I've been at this gig for almost 30 years now. I went to the U for law school. I've worked at a couple big firms, Snow Christensen and Durham Jones and Pinniger back in the days. So,
and I'm Brent Hawkins. I'm at Bennett, Tueller, Johnson and Deere. I graduated in 1997. I like Rand have kind of a background with some other law firms. I went to school in Chicago. I began work with Kirkland & Ellis. When I came here, I first worked at Snell and Wilmer for a little while before going to Dorsey and Whitney, and then to my firm. And my firm may be on the larger size of small because we're now almost 45, 50 attorneys. So, I'll have kind of that interim perspective, I guess, as we talk.
Great, thank you. So, for those of you that weren't able to be part of the other two webinars we had on this topic, this is part 3 of the Changing Utah Legal Market. We had part 1 from the large local firms, and part 2 was the large national firms that have moved into the market. And so now we have part 3, which this is the small, mid-size boutique firm perspective. So my first question is, have either of you and your firms seen the transition with the ability to obtain qualified attorneys to work for your firm? And then the follow-up of that is, because of what's happening in the market now, are you looking to hire more students or more laterals?
That's a great question. I think, for us, we've always loved hiring right from school. Not sure exactly why that is. It's hard, maybe in part, to kind of hire laterally for us. And you never exactly know kind of who you're getting. If you're hiring laterally, you might get someone who's awesome or someone who just isn't a great fit for a law firm. What we're finding right now is that, yes, a lot of students coming out are expecting really high salaries, and that's because they can command them in the current economy with national firms coming in. So it's becoming harder for us to find those candidates. They sometimes go elsewhere. But we try to still have a competitive kind of opening bid and kind of describe how we're different from some of those other firms. And we're also, kind of actually hiring more laterals. We have, I think, of our 3 or 4 last attorneys, they've all been laterals from other firms that have wanted to come back to this market and have been at big firms and realized kind of some of the pros and cons of a bigger firm versus a smaller firm.
Yeah, I'm kind of the same way. I prefer actually hiring in law school and having them work for me during law school. IP's got a fairly steep learning curve. And if you can get somebody in law school and have them for a couple years before they come on as an associate, it gives you the chance to build that and get over that learning curve kind of slowly and let them just adapt to it. And so that's what I've usually preferred. The downside of that, of course, is that you're picking up all of the training costs, which, on the front end, when someone comes out of law school, they're usually not really prepared to be profitable. It takes a lot of time to learn how to do things properly. And so you end up, your first couple of years, you're usually not really making any money off anybody. In fact, some people I've had that over the years were, fairly large losses the first year or two, and then turned out to be great attorney. They just needed a little bit more time to get in their groove and find what they like to do and what they did well at. But that's a downside, but it's something I take on just because I prefer working people in. My experience has been better with people overall with people I've hired during school than trying to do laterals.
So, it would seem to me, and correct me if I'm wrong, but it would seem to me that the smaller the firm, the more value there would be to having a student come out that is quote unquote practice ready. They've done more clinic work. They've done more like hands-on types of classes. Is that true? And would that lessen that learning curve a bit?
Absolutely.
I think so too. And there are some, I mentioned I do transactional work. So I do mergers and acquisitions, venture, private equity, kind of corporate work. And historically, that kind of whole side of practice has been ignored by kind of clinical programs in law schools, but that's changing, and now a lot of law schools have adopted kind of more transactional focused clinical programs where you learn how to do things like draft a resolution or think about a purchase agreement and the like. And those sorts of folks that have that experience are able to Rand's point, kind of hit the ground running a little bit better with us because they kind of know their way around those sorts of documents and what they're doing.
So let's assume that there's a 2-year out attorney who came out of law school, went to a big national firm, and then wanted to come back to be in a smaller mid-sized firm. Would you view that attorney as the same way you would view a brand new graduate, or would you view them as a 2-year attorney had they worked with you from the beginning? Does that make sense?
Yeah. I think, looking at our firm, the answer would be, it would kind of depend on what they were doing at that first firm. If they were doing a very specialized practice, let's call it like mortgage securitization, for example, then there wouldn't be a whole lot of relevance to our practice. That said, we wouldn't dismiss that person. 2 years out is not very far. We would still say, hey, we can tell you're bright. You know kind of how to spot issues and to address issues and to do kind of good quality work. And you've suffered through working through that kind of mortgage securitization work. We think that you can absolutely be a good fit here. But yes, there are a lot of things that you don't know yet. And we're putting kind of faith and trust in you that you're going to be able to kind of help out here and kind of do the stuff we do.
Yeah, I totally agree. I mean, if you get an attorney who's been in a big firm and say, for example, all they're doing is patent cooperation treaty work, little narrow niche, they're going to be viewed as more like a fresh out of law school student because they're not going to know how to do a lot of the stuff we do. And the smaller your firm, usually, unless you're a super specialized boutique, the broader you need to be able to do, because you may have a bunch of patent litigation going on right now, but 2 months from now, it may be almost all prep and prosecution work for patent work.
The last lateral we took into our firm actually didn't have a transactional background. He'd been out for like 7 years, but he was still kind of stuck doing kind of diligence and background work in litigation, right? So he was still doing kind of file review work. So we took him on. We know that he's coming on board here without much kind of background in transactional work. We know he's a bright person. He's willing to kind of not get full credit for his time served, his 7 years doing that other work. But we're excited to have him and think that he'll be able to be a great attorney here. But his prior work maybe isn't exactly on point.
What about the pay scale for those guys? Do you pay them as a 7-year out, or do you pay them as a?
In that case, I think we treated him as like a second or third year out. And he was, by the way, with the big firm, so he was earning almost mid 9 figures when he left, right? So so he's earning a lot less with us now, but he saved a lot of money and kind of realized that he wasn't on kind of a great path and didn't like litigation. So he made what almost kind of amounts to kind of a career change for him, in his situation.
Yeah, our compensation system is totally a flex system. So people aren't necessarily put in a particular slot. We look at what we think they'll generate and then allow them to work it out. And, their salary will adjust with what they bring in.
So how much emphasis do the small firms put on the young attorney for doing their own rainmaking?
I think for us, it's secondary. What we care a lot more about is quality and efficiency of work. Quality is the first thing, efficiency is the second thing. We're not worried about people rainmaking for a good 5 or 6 years. We do kind of are concerned if they don't have what we perceive to be the skills of rainmaking, or have some real personality quirks or hygiene issues or whatever else it is, right? That might make us doubt whether they'd ever kind of be in that position, because that is important. We need that as well. But the first kind of things we look at are just pure smarts and quality of work and efficiency. Those things are key, because what matters most for us is kind of keeping our current clients happy and well served, right? We do want them to be thinking about generating their own work, but we want to make sure that they're able to kind of be kind of a good fit for our clients and our work at the beginning.
Yeah, I think it's the same for us. And for us, it's key that somebody look like they have the skill set where they'll be able to develop clientele. Because what you don't want is somebody who just comes in, kind of feeds off the rainmaking of other people and is like that all the time. I mean, I've had people who do that, and it's hard because it's harder to do reasonable billings as you age up as a lawyer if you're getting hand-me-down work from other people. Unless the clientele grows where you're getting more and more partner level work. You need people, as they approach partnership, to be generating some partnership work instead of just taking from the other partners.
I think that's right. I think one of the things, to Rand's point too, is that and why quality and efficiency are so important to us is because they will be their kind of own source of work. I'm thinking about one of my partners who's a lot smarter than me, but he has some conditions, like he has hearing and speech impairments. But he is very, very smart, very, very capable, and perhaps he gets judged by folks, attorneys, or even clients unfairly. But once they get to know him, they don't want to talk to me or someone else anymore. They want to talk to him, right? Because he is so competent and so capable. So if you don't have that quality and efficiency, then you can't, in my view, and I guess there's some exceptions, just be a very effective rainmaker and kind of have good relations with clients.
So there may be out in the market this superficial impression that if you've worked at one of these giant national firms, that you are somehow smarter or have gotten better experience than if you came out and immediately went to a small mid-sized firm. Do you think clients view it that way? And do you think that clients would view your firms as having achieved some kind of coup if you can hire those lawyers?
I don't think our clients care. In fact, when I went to big law for a while, it actually scared some of our clients away because they just assumed that automatically meant my bills go way up. And if they're comfortable with the lawyer, they don't care where they went to law school. They don't care if they've worked at a big firm or not. It's just is this lawyer doing a good job for me. So I think that it can help among lawyers if you say, yeah, I worked at Cooley or I worked at some national firm. But it's basically just saying you were probably pretty bright, but that doesn't necessarily mean you're a great lawyer. I mean, I've known some really bright attorneys who, just struggle to really be efficient and rainmake and practicing law. So, for my clientele, of course, my clientele are mostly smaller companies. Some huge companies, maybe they're impressed, but for my clients, they couldn't care less.
I think both things are true, Lori. I think that, what we face sometimes is for larger clients that maybe have outside boards, they've never heard of us, right? And so they are immediately a little bit suspicious and say, well, why aren't you using kind of big firm? I have connections there. And sometimes that happens to us, right? And of course, we're not super happy about that, but we get it. We're not a known commodity nationwide. That's certainly something that we can't really fight against at some level. On the flip side, we have had, with respect to a lot of matters, some of our competitors and colleagues go with national firms, and to Rand's point, their billing rates have gone way up. And we've said, hey, would you talk to us? Would you help us? We were formerly using so-and-so, but their rates have gone way up. We need some help, and we know you, and we like you, and we know you do that kind of same quality of work. And so, it can be sometimes frustrating a little bit with respect to bigger clients, but it's very useful, I think, to also be more efficient and to kind of care about what our clients care about, to kind of focus on not just, lawyers are often criticized for caring about commas and about punctuation and things like that, and we don't tend to care about that. We tend to care in our practice much more about tax impacts for a transaction. How do we get kind of more dollars in for our client, looking at things like net working capital adjustments, purchase price allocations, making sure transactions are tax-free or tax-deferred. How can they do kind of charitable planning in advance, things like that really matter to our clients. And that also are hopefully provide, with respect to our bills, something of a return on investment for our clients instead of just billing the heck out of our clients for no apparent reason. So that's how we have to kind of focus our practice, at least in what I do.
So I'm going to admit something, and so I'm going to kind of maybe shame myself here, but I watched part of the cross-examination of the Johnny Depp trial, and I wished so much that cross-examination had happened last spring so I could show my students what a really good cross looks like. But I was watching that, and anytime the lead attorney would ask for an exhibit, there are 6 people back there immediately pulling up an exhibit. There's no looking through a file or trying to look through a notebook or anything to pull up the exhibit that you need to talk about. I mean, it was almost instantaneous. So there are things that these big firms can do that are charging $4,000 an hour that maybe a small boutique firm can't do. Do you see that as a hindrance, or do you see it as a way to capitalize on bringing more real value to your client in a way that the client needs?
I think that it depends, right? I mean, I have situations where I refer my clients to big firms. They'll have a particular issue, and I'll tell them, look, this firm has expertise in this area. It will cost you less in the long run. to go and use this person because they know what they're doing. And, in a day, they'll resolve this issue. And it would take me a week or two to get up to speed, learn the law well enough, and do hopefully as good a job as they would do. But for a lot of my clients, that's, a once every couple of years type of scenario. But the rest of the time, do they want to be paying, over $1,000 an hour? One of the clients I actually referred to somebody, the person I referred them to did a really good job. There was a related piece of litigation, which he said, oh, well, I'll just keep at that firm since they've kind of got expertise there. And he came back to me and said, oh, I made such a mistake. He said, I should have had you up there. And I'm like, why? This is a big name firm. And he said, the attorney who was charging him $1,200 an hour was literally shaking while he was talking to the judge.
Ooh.
And he said, I'm sitting there going, this guy's charging me way more than my other counsel. And, I've seen Rand litigate and he's not shaking when he's talking to the judge. So there's times, there's really times where the big firms, I think, add a huge amount of value. When you have a particular problem, you get a specialist who, it's like a brain surgeon. You don't want to go to your GP for brain surgery, but I'm not going to take my kids to the brain surgeon when a just normal pediatrician will do a good job.
Yeah, and I think as this is about kind of small firms and groups like that, I think Rand's making a good point. Like if there's a patent prosecution matter, we don't do that in our firm. We have litigators and we have folks that do kind of other areas of the law and real property and other things. But that's not something that we can or should do. And so we'll refer out to kind of other practitioners that meet our clients' needs, such as Rand, who focuses in that area of law. So one of the things you have to kind of do and be careful about, as you know, Lori, is kind of know what you're good at and what you're not, and even if it's within kind of your area of presumed expertise, I know for myself, I'm not a fund formation attorney, right? Even though that's transactional, and I have a lot of clients ask me for it, still, I'll refer that out because it's just not what I do. If it's an M&A matter, yes. A mergers and acquisitions matter, yes, I'll do that. But you got to kind of know what you're good at and what you should not be messing around with, as a practitioner. And I worry a little bit about, about the very kind of small shops that kind of presume to do everything, because I can't imagine they do any of it well at all. So there's some balance there a little bit about kind of what you're good at and knowing what you're good at and some specialization.
So with all these big national firms moving into the market, have you noticed any upheaval for your firms in terms of finding quality talent if you're looking for it? Or is the national firms snapping up all the good lawyers? And the perspective seems to be that now that we have these national law firms in, that everyone is looking deeper into the classes than they would have previously. And having been forced to grade papers and realize that the spread between an A and a C is minuscule, that maybe looking deeper into the class is a good thing.
Yeah, I think you find a lot of really good attorneys who just weren't great law students. Right? I know a lot of attorneys who weren't coif, who weren't cum laude, whatever, who I think are just amazing attorneys. And I know a few, and I've actually hired a few over the years who were top 10% and stuff and really struggled to do good regular legal work. They could test well, but whether it's problems with time management, whether it's problems with being able to generate clients, whatever. So depending on what the needs are of the firm, that solid B student may turn out to be just an awesome attorney for your firm. And I think we put a little bit too much emphasis on where you graduated in law school and not enough on what are they going to turn out to be as an attorney.
we still put a lot of emphasis on law school and grades. But I think, at least in terms of when I look at a resume, I care as much about kind of undergraduate performance and what's going on. Like if someone has kind of like a hard science background or something, then more credit to them, or accounting, because we use so much of that in our transactional practice, then that has some extra value points. Or if I'm aware of if they've been working kind of full time while going to school, that matters, because that's a lot harder than if you're just kind of a dedicated student. And it shows a fair amount of resolve and ability to kind of take care of yourself, which are important things, I think, for skills for young lawyers to be able to do, to manage themselves and to work under tight timetables and be efficient. So those things, I think, do matter to us a lot. We've been fortunate as nationals have come on, they've of course bid for a number of our attorneys. We haven't had folks leave. A lot of folks have found that it's been hard to retain attorneys. I don't know exactly how we've been or why we've been fortunate in that respect. I hope it continues, because having attorneys leave is very hard for a firm like ours. But I guess to your point, yeah, we still kind of look for really quality candidates, both in terms of law school performance, but also undergraduate and life experience. And we are also more open than we have been, seeing kind of non-traditional candidates, particularly laterals, coming from other firms back into our market. We've, historically not been as interested in candidates like that, but we've had our last several candidates have fit that description.
So when lawyers moved firms, before the big national firms moved in and lawyers would change firms, there were always the confidentiality problems that arose with clients and maybe conflicting out clients and those kinds of things. Do you think it is the same if you take a lateral from a national firm, or are your client bases sufficiently different that those confidentiality problems wouldn't necessarily exist with a lawyer that would come to you from a large national firm?
I think it kind of depends a little bit. We are careful to always do conflicts checks, but I'm thinking about like one case, and maybe this will say too much, but it was, I think, the same story I was telling you about this lateral who is coming in to do transactional work with more of a litigation background. He did a lot of work for Volkswagen in the TDI litigation, right? None of that is relevant to our practice. We don't represent Volkswagen, nor, we don't have any, we're not part of a class action on the other side of those that purchased TDI vehicles, that big diesel performance scandal. So in that case, it made our job easier as we kind of thought about conflicts with that lateral coming in. There's fewer boxes to check.
Yeah, and the same for mine. My clientele are mostly smaller companies. Occasionally we have run-ins with national companies, but for the most part, we don't. But the challenge is more, when you bring them on, the challenge is more, are they going to have a broad enough skill set to cover what we cover? Because, unless they've been out quite a while, they've probably got a really good experience in a fairly narrow area. And the smaller your firm is, unless you're, hyper focused on one area, the more you need somebody who can play all positions.
So this issue came up when we had parts 1 and 2, and that was the impression that when a graduate goes to a big national firm, they get stuck doing document review for 5 years, and they never get to do anything, meet with a client or go to court or draft a real contract or something. Do you think that holds true, or do you think that is just an impression that people have?
I think it's hard to say. It depends really on the nature of your practice and where you go to a big firm. I think some big firms you might be kind of put into if you're working on, let's say, an IPO, initial public offering for a New York firm, you might be kind of cordoned off and doing kind of more your diligence review, or if you're working for Volkswagen for kind of a big litigation matter. But for other firms, like I started at Kirkland Ellis and I did private equity work, and I did several things and several kinds of things from the beginning, and it was good training, so I I don't have bad things to say about that. I think it much depends upon where you go. I've had one friend who did go and worked in securitization of mortgages, and his experience was different than mine. He valued it and liked kind of having a nice kind of careful cordoned off practice, but it made kind of his ability to transition that elsewhere more difficult.
Yeah, I think it's the same. And a lot depends on your firm. I've seen firms that do a really good job of trying to take associates to hearings to get them involved, so they at least get to see the mechanics working as opposed to just doing doc review. And then I know other people have gone to national firms where literally they were billing 2,200 hours a year of looking at documents.
I think one thing, Lori, to your point, is that we can't afford not to have, even our young attorneys kind of work on agreements or talk to clients. Even if it's a matter of doing diligence and filling out disclosure schedules, we'll need to have them in the meetings, hearing what the client is saying about their material contracts or litigation or whatever as we're working on agreements. Otherwise, we're not serving our client. We don't have the luxury of just billing our clients millions of dollars to review boxes of documents. It's not kind of part of our practice.
So, Brent, you kind of precipitated my next question, and that is, I can perceive, because I had a litigation practice, how easy it is to take a brand new attorney that's been out for 2 days and take them to court and have them participate in a mediation or a client interview or do all those things. How does it happen in the transactional practice?
I think for me, at least, it happens in 2 or 3 ways. We do have, kind of young attorneys be on deal calls where we are negotiating points and trying to structure things. We certainly include them in kind of emails and kind of structure diagrams about how things are coming together. We try to say, all right, we have this transaction. Here's kind of a closing index of maybe the 30 documents that we're going to need for this. Here's where we need your help. It's on documents 13 to 18. And here are some forms for kind of where you can kind of think about kind of starting kind of drafting what those will look like. And here are some of the core issues you need to be thinking about. That's how our training is not probably as formal as some of the big national firms that have very kind of well thought out kind of document management systems and knowledge bases and training practices. It's more kind of on the go, on the fly as needed, which, I know it's probably sometimes frustrating to young attorneys, but it's also realistic.
Yeah, I was going to say,
practice focused.
See, because law school really is just boot camp, right? Get ready to go to the war. So, Rand, you said at the beginning that IP practice can have a steep learning curve. So how do you perceive it being different coming into a small boutique IP practice like yours versus going to a giant national firm that does some IP work?
Well, if you go to a big firm, you're typically going to get assigned within a group. So if you're have a patent, if you're patent registered, so you've got, you're registered with the Patent and Trademark Office, you're probably going to get funneled into the patent group. And then if you've got a good science background, you're probably going to be funneled into the patent prosecution group. And so you're going to get probably really good development in writing patent applications, filing them, responding to office actions, and pushing them through. But you're probably not going to spend much time doing patent litigation. You're going to probably spend no time doing trademark work, copyright work, or litigation regarding those. And so you'll get to be, my experience with most people who've gone to big firms has been that they're really good in one area. If you come to a firm like mine, you're going to get patent, prosecution, litigation, trademark, copyright work. You're going to get all of that in the first month. And so you're going to go less deep, but you're going to get a lot broader coverage, which is good, I think, in a way, especially when you're young, because it helps you figure out what you like to do. I mean, I know people who are registered patent attorneys, but they do mostly trademark work because they just like that better. There are a lot who end up doing patent litigation because they like that better. There are a few, there are some attorneys who have split personalities, can do prosecution and litigation. And those are very different skill sets. So it's just, there's a lot of difference in how broad of a base you have. And that really plays, I think that can really play long-term to your success. If you're looking around coming out of a big national firm and a firm needs a good patent prosecutor, you can fit that niche. But if a firm needs, we just have a lot of IP needs, it's going to be easier, I think, to get on if you've had a broad array of experience. So you can do trademark work, you can do copyrights, you can do, because, for some firms, they say, we don't know that everyone's going to be busy doing patent work. Sometimes that cut dies off for a while. Well, if we want people who we can shift over and have them doing something else, maybe they shift over to doing litigation. So it's totally contextual on whether it's going to help you or hurt you. But there's upsides and downsides to both, I think.
So having the big national firms move into the market has caused waves for some firms and ripples for other firms. Have you guys seen it impact you guys, your firms?
Virtually no impact on
tsunami
us.
Or a little ripple?
I think it's been, it's caused an increase in kind of first year compensation coming out of schools, and that's something we've had to kind of react to and think about. It's made, some of the firms coming in are not aiming to do even so much Utah work as much as make kind of Utah kind of a service base for clients elsewhere, right? And so to that degree, it hasn't kind of hurt us. We're always competing against big firms, whether they're in market or not, for kind of top flight deals. So when I say top flight deals, like mergers and acquisitions in like the 9 figures, right? It's almost always, even if it's a long-standing client, we're going to be pitted in a beauty contest to try to repitch our client, and someone else is pitching them. And so we face maybe a little bit more of that, but maybe not that much more. And with respect to kind of folks that have been at regional or even kind of local firms and have moved to national rates, as I mentioned, we're finding a lot more work coming in like the 8-figure M&A space because our rates are lower and folks know us and they say, hey, yeah, we so-and-so is really expensive and we don't want to pay those rates. We know what you guys can do and we're glad to have you. We'd like to have you work on this, and we're glad to oblige. So it means that we have to be kind of efficient, and we have to provide and demonstrate kind of value for our clients and give them kind of a good return on investment.
So I have been led to understand that Silicon Slopes and the creation of Silicon Slopes has been one of the attractive features to get these big national firms into the market. Have you seen that particular client group stay local, or have they moved national? Were they always national, or have you seen much movement?
They were always national. When we talk about Silicon Slopes is not, it hasn't been, and one criticism of it is that it hasn't really been about the emerging tech companies. It's been about the larger established ones, and they've always had kind of large firm kind of client connections or chosen to go that direction. So that really hasn't impacted us in a meaningful way. I kind of agree with you, Lori, that probably the Silicon Slopes probably has kind of attracted the attention of regional firms. I think as much or more than that has been kind of your good work, Lori, and at the U and also BYU, where I think these larger firms are realizing that they're getting great students out of our Utah universities, right? In terms of they're well trained and smart and capable, and so they're saying, why haven't we been tapping into this talent source? And so they're looking at kind of creating these hubs in kind of a post-COVID world where we can have Zoom meetings instead of being in person. Where I think, hey, wait, we can have folks in Utah service clients in the Midwest or on the coast. There's nothing wrong with that, and they're right. That's fine. That's been kind of our experience as much as anything.
It is true that some of the incentive for them to move into the market is they hire our graduates who then move out, but want to come back. And they keep, like we're talking about losing talent that start with us and then go to the big firms. But now it's these big firms losing talent because they hire these students and then they want to come back home and live here because of the quality of life and the environment and everything. So I have heard that part of the incentive was it's a way to keep the people that they hired.
Well, that's really true. There's a lot of folks from particularly University of Utah and BYU who want to come back here, and they've been with the big firms. And this provides kind of a great opportunity for them to do that. I'm aware of like folks in my neighborhood from that fit that description. They've been partners in California and Texas in a couple of cases, and they're back now because their practices are portable and they're still working for the big firms.
Have you noticed any ethical issues with people bouncing around firms a bit more than usual?
We've been blissfully kind of ignorant of those, Lori, in that we haven't really had those kind of, we haven't tried to, and we haven't landed any kind of incoming partners with big books of business and practice groups, nor have we lost any. And so but I am aware of those issues exist. And so I don't have a very kind of thoughtful and insightful response to your question just because we haven't experienced it.
What about you,
on our side?
Yeah, it really hasn't been a problem for us, but yeah, I think if you're bouncing around a lot, it raises conflict issues. Because you may not know everything that was going on at the firm, but you're charged with knowing everything that was going on with the firm. So.
And certainly, in the kind of the tech space, people leave from, let's say, one company and they go and start another company. And there may be questions you're not even aware of about, well, did they take, maybe some intellectual property from their former employer and things. And so conflicts can be really hard to sort out at any level, even when you're careful.
I was reading cases on the 10th Circuit docket yesterday, and there are employment agreement disputes with restrictive employment agreements. And I'm not exactly sure, but I have the impression that Utah seems to be moving away from enforcing these very strict employment agreements. And I'm wondering if you think those would be an effective way to keep lawyers.
You mean subjecting lawyers to like some covenants?
Yeah, restrictive covenants.
I'd be the first to say that I don't know ethics rules very well. And there's a partner here who does, that I kind of subject these things to. But what I've understood, and you'll both correct me, is that for lawyers, really, there's a strong public policy against any covenants not to compete, in part because, at least in theory, we value so much our clients' ability to choose whoever they want to serve them, right? And so how dare you say that a company can't use Rand to provide legal services? That's going to be, I think, struck down pretty easily by most courts. So I don't see that being I don't see contractual restrictions working to kind of stop lawyers from moving about. I think, certainly money is a motivator for lawyers, as it is for everyone. Quality of life issues and kind of where firms are and kind of the type of work that clients want, that lawyers want to do. Those things are going to be the key drivers, more kind of economic incentives and lifestyle incentives than contractual restrictions. But I'll let Lori, I'm sure you probably know ethical rules and Rand better than me, so I'll be quiet and let you.
No, I think you're right on point with that. Although, there has been a trend in a bunch of other industries the last couple of years of having basically agreements where you have to reimburse training. And I wonder if firms would try and say, all right, fine, if you leave us during the first 2 years, you have to repay us $10,000 or $20,000 for all this training that we spent on you. That would probably be legal if you can get people to sign off on it. I don't think it would.
One other thing,
people to you, but as far as prohibiting people from leaving or competing, I think non-competes are, my understanding is they're not viewed as ethical because of the very reason that Brent pointed out. the
I
ability
think
of people to
I
hire
think one of the
attorney
things that I think that a law student ought to think about, and I don't know exactly how to describe this adequately, is that law firms are mercenary and dollars matter, but they matter even more for like a larger firm than a smaller firm, because we don't advertise things like profits per partner. We know what those things kind of are, but they matter a lot for like the AmLaw 100, right? And so they're much faster to hire, frankly, attorneys that we would not, I'm going to say this, I don't mean to be kind of elitist, that we would not give an interview to, right? Particularly in the last couple of years. They're hiring people left and right, but they're also very willing to cut people loose for performance or other reasons, or just that they don't have the work for them. And so, I guess our view is a little bit, it sounds kind of maybe cheesy, but we have kind of a more of a familial relationship. We didn't lay people off through COVID. We, as partners, kind of took pay cuts, and as we kind of got through that, I'm not sure, and that's, I think, what we would do if we find ourselves in an economic turndown. We would be very slow to kind of to let people go, unless it was for a really significant performance issue, where I don't think that you'd find quite that same kind of loyalty from kind of big firms.
So we've heard a lot over the years about work-life balance, and I seriously hate that term, because to me it rings of you're not having life when you're at work, right? I mean, it's more like kind of a quality of life discussion rather than a work-life balance discussion. But my own personal biases on that phraseology aside, do you think that a local firm has more flexibility to offer a quality of life analysis over one of the large national firms, or do you think that's a mistaken impression?
I think kind of both. Randall, you go ahead, I'll weigh in.
Oh, I think they have the flexibility. Do they use that flexibility? Depends on the firm.
And it's hard, there's been a lot of talk about, work-life balance and among privy associates and the like. But one of the things you can be kind of maybe more readily a jerk at kind of a large firm than you can at a small firm. If I have a colleague that I really value that wants to take a lot of vacation, that's okay. I have to kind of grin and bear it, and I may have to pick up a little more slack, as a result of that. That's kind of part of the deal, I guess, for being at kind of a smaller firm. We have fewer kind of resources to kind of look to allocate and share work, right? So in that sense, at the same time, that puts a burden on me to kind of know kind of what kind of clients I want to have and what to say no to, right? And say, no, I'm not going to do it that fast, or no, go talk to someone else because I just have too much to do, or I don't like you, I don't want to do work with you, which is a luxury, of course, that we have.
Yeah.
Yeah, I think smaller firms have an easier time adopting, flexible arrangements. I mean, over the years, I've hired a fair number of female patent attorneys who didn't want to work 40 hours a week. Some of them only wanted to work 20, and some of them wanted to work 40 one week and none the next week. I think it's a little easier in a small to mid-sized firm to accommodate that than a national firm, because you're having to create custom agreements for everybody. And I think the bigger you get, the harder it is to justify keeping on top of all those things. So
how have your respective firms found the impact of the pandemic and restructuring the way we work? Because I know from my perspective, I can be more efficient doing certain tasks if I don't have to commute to the office. And I don't know if law firms, I mean, I've heard that law firms have also adopted that posture for a lot of their people.
Rand's got a pretty tough commute. Although I can see from your background, you're maybe downtown or somewhere today.
I had to have an excuse to actually wear a tie and a collared shirt. And so, I have this closet with all these clothes that don't get worn anymore. My dry cleaner has forgotten my name. And for me, 90% of days are shorts and a t-shirt in my home office. A lot of my clients would prefer to have meetings by Zoom. And so, for the ones who don't, I have office space available. But yeah, it's totally changed. I never thought I could cut the umbilical cord to the office. And now it's like, I have to go to the office once this week. So I think it can improve quality of life. I think a lot though depends on someone's family circumstance. If you got a bunch of young kids, it's really hard sometimes to work from home just because you have, kids running in. Well, I say that, but anyone who knows my daughters, even though they're like in college now, they're still coming in all the time. But it's what works for everybody. I think the cool thing about it is I think it lets everybody adapt to what they want. I know people who go into the office every day, but the office is mostly empty. So they're getting more done in the office because you're not spending as much water cooler time.
One of the really rewarding things for me in practice, and I didn't really realize that I found it rewarding until like a year or two ago, is just being able to kind of talk to clients, and so I really kind of like kind of the chance to use Zoom and other kind of platforms to connect with clients better. It's much easier and better to kind of be on a call, kind of talk with the client kind of face to face that way, even though it's not truly face to face, and screen share and work through things, together.
Oh, yeah.
That's a lot more fun for me than trying to kind of have this kind of bizarre kind of email or phone tag to try to figure things out or to draft something kind of crazy and have a client, not kind of understand what I'm trying to do. So that's useful. I think that's not maybe your question, Laura. You were talking more about just kind of where folks work from as part of COVID changes.
Not necessarily. I think somebody said this the other day, you never want to waste a good crisis, because I think there are a lot of things we've been able to learn through the pandemic about how we work and other kinds of things. So it wasn't just where we are, but also functionality. So thanks. There is a question from the audience. From a cursory look at both panelists' firm attorney bios, it appears there might be literally one minority diverse attorney. Larger firms are sometimes beholden to Fortune 500 publicly traded corporate clients who require outside counsel to have a certain level of diversity on the legal teams they hire. Is the lack of diversity of the attorneys in your firms a result of not having to deal with clients of those requirements? How does that dynamic play into your hiring decisions? Curious as to why there is such a small number of diverse attorneys at your law firms in general.
I can speak to some of that in my firm. We would love to have more minority attorneys and more women attorneys. We don't have very many women among our attorneys, and we keep on trying to offer women to come and join our firm, and we haven't been very successful in our hit rates, and so that's part of the reason why we don't have greater diversity. It's just because, and we're working on it. We're trying to do that and make more offers and reach out further there, because we know it's not really about. This is going to sound maybe bad. It's we care about having kind of a different set of experiences and different set of kind of views as to kind of issues in the law that we practice, because doing so will make us better and be and have a fuller range of insights for our clients. Whereas if we're all the same in our firm, then we won't have that. We won't be able to have as richness of a response for our clients. So that's my view. I know we're working on it, and we have been kind of unsuccessful, not as successful as we'd like to, frankly, in terms of having more attorneys of color and more women among our ranks.
Yeah, historically, we've actually had a disproportionately large number of female attorneys. It's just not the case at the moment. Part of the issue is, with minority attorneys, there's just not the supply to meet the demand at the moment. I mean, there's a lot of firms that are implementing DEI type programs, and so they're actively recruiting. And Utah is still a pretty white state. There's just not as many. I mean, I think the numbers are increasing, but historically, there just haven't been as many minority attorneys in town, especially in the IP area.
I think maybe more answering your question to that point, we have not faced pressure from our clients. We don't have Coke and other big kind of Fortune 100 clients, so we don't get pressure to kind of that kind from our clients. It's kind of self-imposed pressure.
And that's very encouraging to hear. As I read the question, it would be, I think it would be a shame for law firms to feel like the only reason why they want to diversify is from client pressure, rather than from, Brent, what you said, the richness that can bring to the overall experience, both for the firm and for the client.
Well, I think if you've got a client who demands that, right, you're going to focus even more on getting those people so you can keep your client happy, right? So, other firms are going to say, look, we'd love to have more women and minorities, but there's not an absolute urgency that needs to be a higher priority of how we rank people. Whereas if you've got Coke or you've got, when I was at Durham, I know we had one client who they were really pushing that. And so you move female attorneys onto their work and look out to try and hire more in that. So I think there's, some pressure there, but you also have to look at the supply and the skill sets, because if there's 5 women attorneys out there who are available, but none of them do the type of law that you're doing, there's not a lot that you can do.
We need to get more women kind of interested in transactional law. So Lori, we're going to look to you to kind of help on that.
Well,
and I say that, we do have a couple in our firm who do that work, and they're great. And of course, that's my background, because I'm a transactional lawyer. So,
I'm this gigantic moot court advocate. I think it was one of the best things I did in law school, but it's so exciting now that among the competition teams that we have at the law school, we have one for the transactional law competition, and we have one for the patent application competition. So we are offering competition teams that aren't just go argue an appellate brief. So that's part of the way law school has expanded from the time I was there, that I think is really exciting.
Same. I wish those programs were in existence when Rand and I were going to school, and you too, Lori, I guess, that would have been great. I never wanted to be a litigator. That stuff scared me. I don't like fighting. I like structuring things. So.
Well, thank you. Our time is up. I really, really appreciate you guys. This discussion has been really interesting for me. All of these 3 parts have been really interesting for me. I've heard completely different perspectives from each of the groups, but what I have heard the most is the encouraging positive outlook that the national firms and the local firms of all sizes are looking what the changing legal market is doing for the community and for our graduates and for BYU's graduates, and the good things that are coming out of it, and the good ways firms are able to take these change and manage it in a positive way. So that's really been really encouraging for me, because my initial reaction was negative. It's like, oh no, what's happening to my world? But, well, not my world, but the world I live in. But it's encouraging to me to see the positive way the firms are handling it and dealing with it and making the changes that work. So thank you very, very much.
Thank you.
Thank you to all of you that participated. I hope to see you at the next webinar. We'll have one next week on a Utah Supreme Court decision regarding arbitration in family law cases. And I hope to see many of you there. Thanks so much.